Hi, everyone. This is the first recorded lecture I'm doing for you in environmental law. So it's the first asynchronous lecture. I'll be doing a number of these over the course of the semester based upon how much content I think we can comfortably cover in a class. So the purpose of these particular recorded lectures is to give you something to read at your own pace before the lecture takes place, so it won't necessarily prolong our actual in-class discussion. So this particular lecture is going to deal with constitutional responsibilities of the various governments in environmental law, which is for the most part the topics covered in chapter 2 in your textbook. So not only will we be talking about the Constitution and how it applies in this particular field of endeavor, together with the division of responsibilities between the provinces and the federal government for the most part, and we'll also deal with the very specific provisions that apply to environmental law. All right, and so it's important that you look at this if particularly you haven't covered this kind of topic before. Most of you who have taken any kind of jury class with me in the past will have the basics of this particular lecture with the addition at the end of the environmental law component. Okay, so let's go through this. So this is the constitutional responsibility for environmental law, right? So the Constitution itself, an incredibly important document, is the source of any government's authority to exercise jurisdiction over its peoples and its institutions. The first constitutional document that Canada had as a nation was put in place by the colonial government in Great Britain. It was put in place in 1867, and it was called, and you can tell from the title where it came from, the British North America Act of 1867. So this is obviously the founding document for the country of Canada that was created in that particular year. Prior to that, the previous territory that became Canada was made up of 4 colonies. That's what they were called, which were Upper Canada, Ontario, Lower Canada, Quebec, New Brunswick, and Nova Scotia. So those were the 4 colonies that came together with territories that were primarily known as Rupert's Land, owned by the Hudson's Bay Company, that became, for the most part, the Prairie Provinces. So that's what this, so Confederation, which created the country in 1867, again, was made up of these particular provinces. Right, and what the BNA Act, that's what we use for a short form, it recognized clearly the power of the British Crown and the Parliament of Great Britain over Canada. So make no mistake about it, Canada very much was a colonial outpost of the British government before and after Confederation for a great period of time. The most important thing that the British North America Act did in 1867 was to create the powers between what were then, again, those 4 colonies that we just talked about, and what would become a new federal government known as Canada. So prior to 1867, there really was no federal government structure in place. Anything to do with the provinces, formerly territories and colonies before then, were governed by the British government in London, England. Clearly, the prime motivation for Canada being created, and this was a function of Sir John A. Macdonald, was commerce, right? And really, money is the driving factor for almost anything that takes place in the political spectrum. So what Macdonald basically did, this was in 1864, 3 years prior to Confederation, at what was known as the Charlottetown Conference, was to bring together all of those leaders in those 4 colonies at the time and basically convince them that they would essentially be richer, certainly become wealthier than they already were, and trust me, they were already wealthy. They wouldn't be leaders or political leaders if they didn't have money. But that the Macdonald's proposition was to create this new country that would in fact make them even more rich than they already were. And in order to do that, he proposed that this new entity to become Canada would build a railway from essentially coast to coast. All right, and the purpose of that, he told the boys in Charlottetown, was that as we go west towards the Pacific Ocean, we will be able to bring all of that territory again in the hands of the Hudson's Bay Company into the country of Canada. We will add new provinces to this country as we go west, right? So that was certainly an incentive to create a larger entity than what the four colonies created. And to do all the things that going west would do, which was things like create an opportunity for immigration to take place in these new territories, and by basically sending these immigrants, again, mostly from Great Britain, coming to Canada and putting them out west, it would create a market for the manufacturing sector, which was the primary businesses of most of these leaders in Charlottetown in 1864. At the same time, while Macdonald who was from Ontario, was promoting this new country, all of the leaders in these four colonies to become provinces also said, yes, we understand that creating this new country will have these broader economic benefits to us, but we are still very much ourselves in our own jurisdictions provincially, and in that regard, when it comes to dividing the powers between the federal government and these new provinces, the provinces or their leaders said that we intend to keep within our sphere of jurisdiction those things that are important to our own identities. So that's things that deal with culture and ethnicity and languages. So obviously think about Quebec in that regard. All right. Prior to Confederation, there was no common system of law in these provinces and territories prior to Confederation, but at Confederation, one of the provisions of the BNA Act was to incorporate the law of England as it existed in 1867 into the law of Canada to every one of the provinces, with the exception of Quebec. Quebec did have its own system of law that was in place from prior to 1760, when France still had an interest in North America. The civil code, the French civil code, was in fact the code based upon the Napoleonic Code that applied to Quebec in what are considered to be civil matters being property law, contract law, trust law, and those kind of things. So all of the other provinces adopted the English law, which was the common law, right? Hopefully most of you are familiar with that. But in Quebec, the civil law was applied. That was with respect to, again, civil matters, but when it came to criminal law, it was agreed amongst the provinces and the new federal government that they would have the same law across the country. So Quebec, for instance, has the same criminal code as all the other provinces. One of the things that this new country decided that it wouldn't do, however, in creating this new entity, was to basically entertain the prospect of having its own jurisdiction over foreign policy. So the thought at the time, and one that was embedded basically in our way of working for this new country, was that foreign policy would still be dictated by the British Parliament sitting in London. So even though we became our own country in 1867, we did not have any jurisdiction over foreign policy. And likewise, it was decided that the British North America Act, which was in fact a statute enacted in London, could not be changed without an amendment again in London. So notwithstanding the fact that we became a new country, we did not have the power within our own borders to change our fundamental constitutional document. When it comes to courts, basically, Likewise, the Supreme Court in the land when Canada was newly created was the Judicial Committee of the Privy Council, which was a committee of the House of Lords, again sitting in London. And although Canada enacted or put into place in 1875 its own Supreme Court, called the Supreme Court of Canada, the Supreme Court of Canada was not the highest level of appeal in Canada until after 1949. So if you were to appeal a matter, doesn't matter whether it was criminal or civil, within Canada after 1867, you would go from a trial court decision in a province to a provincial court of appeal. And after that, you would then take it from the provincial court of appeal to the Supreme Court of Canada. And again, if someone was still unhappy with the result there, you would further go to the Privy Council in London. The Privy Council still exists, and as a matter of fact, it is still the highest court of appeal in a fair number of what were formerly British colonies. So while it doesn't apply to Canada any longer, it's still the highest court if you have issues, for instance, in Jamaica or Antigua or Aruba, those kind of places. They still have their final appeals determined by a court in London, England. So fast forward now from Confederation in 1867 to 1930. All right, so we're talking about 60 odd years into the future. It became a pretty common discussion amongst Commonwealth countries at the time that perhaps we should change some of the provisions that were still in line as a function of the decisions made in 1867, particularly dealing with the power over foreign policy. So in 1930, there was a Commonwealth conference. So Australia and New Zealand, India, Canada, they came together in 1930 in Westminster, which is in London, to basically take part in the enactment of the Statute of Westminster in 1931. So in 1931, again, it's a British statute passed in London, and what it basically did is that it gave Canada its authority over foreign policy. All right, so that's the first time, and again, 60 years after we'd become a country, that we actually had jurisdiction to deal with our own foreign policy rather than have politicians in Great Britain do it for us. But having said that, we didn't change the methods of amendment to the British North America Act. So again, there was nothing put into place that would allow Canadian politicians to amend our fundamental constitutional document. Right, so now go forward to 1982, right, which is basically considered the year that we repatriated our Constitution, and we did that by way of essentially amending the British North America Act of 1867. It was renamed the Constitution Act of 1867, and it was put in place, it was a ceremony in April of 1982, put in place by the then Prime Minister, Pierre Trudeau. Jean Chrétien was his Minister of Justice, and Queen Elizabeth II came to Canada. So she came to Canada to sign this legislation into effect. So the Canada Act of 1982 and the Constitution Act of 1982, which basically cut ties almost entirely from Great Britain and made us for the first time a standalone jurisdiction. It still had to be signed by the Queen of England, who was representing the Parliament of the United Kingdom. Right, so that's what happened in 1982. And here are the important principles in our Constitution from 1982 going forward. So the first thing is that we have a system, what's called responsible government, not representative government. And what this simply means is that when we elect politicians to go to Ottawa, if you're a member of the federal government, a member of parliament, and or we elect politicians to go provincially, in Ontario, we go to Toronto, to Queen's Park, to elect members of the provincial parliament, so MPPs. That would be the Doug Ford government, or Ottawa, Justin Trudeau's government. We send them there to basically make decisions in a responsible way. So we expect them to make decisions that aren't necessarily always exactly the decisions that we would make, but ones that we feel they would be responsible in making in any event. So hopefully, for the most part, they do make decisions that we agree with, but not automatically exactly what we would agree to on any particular issue. If we had a representative government instead of a responsible government, that would be a government that made decisions only based upon what the public decided how an issue would be dealt with. And so governments that are representative are ones that have a number of referendums and plebiscites to get the opinions of the public on how to deal with matters. So that's representative, and we're responsible. We also have, or had up until 1982, the concept of the supremacy of Parliament, which simply means that Parliament, that's the federal Parliament in Ottawa, has the supreme power to make decisions and laws that apply to all citizens, as long as the government that makes the decisions, the federal government, has the mandate of the people to govern accordingly, right? We'll talk about how that's been amended with the charter shortly. The Constitution also recognizes that the executive power of the government, which means essentially cabinet and its decisions, rest in the monarchy. So that's what our Constitution still says, even though it was updated in 1982. So if you were to read the Constitution, you would think that the Queen has the ultimate power to make laws in Canada, and in the provinces dealing with provincial laws. Every province and territory has a lieutenant governor for that purpose. And in Ottawa, we have a governor general. And so all laws that are passed federally don't become law until they go through the process of making a law, and that process is set out in Chapter 2 in your textbook, so take a look at that. But when that law is made, it doesn't actually come into effect until federally the Governor General puts her signature on it. Our current Governor General is Julie Payette, and she is our Governor General for probably the next 3 years. She has 3 more years in her term. She's been there for 2. And each province and territory has a lieutenant governor. And even though the legislative assemblies in the provinces pass laws, just like we do in the federal government, they again don't become law until the lieutenant governors have signed off on them. All right. Even though our Constitution clearly says that the head of our government is the Queen, represented by, for instance, the Governor General, and the Governor General really can't exercise the authority that the Constitution gives him or her, because it's an appointed position, not an elected one. So all the Governor General can really do in real terms is advise the government of the day. And that certainly has taken place a couple times over the course of us being a country. In theory, the Prime Minister and the premiers in the provinces are chosen by the Governor General and the Lieutenant Governors. That's how the Constitution works. But in reality, they are chosen by the political party that they lead. And the political party governs, whether it's federally or provincially, if they have in fact won an election for that purpose. So the Prime Minister is an elected position within the confines of their own political party. We don't have, for instance, elections to choose our Prime Minister. So there never was an election. Our last election was in 2019, last year in October. There was nothing on anybody's ballot in Canada that said you can choose to put a check mark here beside Justin Trudeau. Totally contrary to what's going to happen later this year in the United States. The United States has presidential elections, so you will or won't be able to put a check mark beside Donald Trump. And for the Democrat, the presumptive nominee is Joe Biden, so he'll likely be on the ballot as well. And you actually get to, in the States, check off who you want to be the president, but we don't do that in Canada. Again, the Prime Minister in Canada will stay in power so long as he or she has the approval of the political power in which they are the political party to which they lead. So in Canada, Justin Trudeau is the leader of the Liberal Party of Canada. And in Queen's Park in Toronto, Doug Ford is the leader of the Conservative Party of Ontario. So those parties are in power. So they were elected by the populace, the citizens to basically govern in their respective jurisdictions. Parties can stay in power so long as they have the confidence of Parliament. If a government is elected with a majority, which means they have more than half of the seats available. In Canada, we have 338 electoral districts, so 338 members of Parliament. For the Liberal Party to have a majority government, they would need 50% of those 338 plus one. Justin Trudeau obtained that majority in his first election in 2015 without a lot of problem. However, he fell below that number in 2019, so the current Liberal government has a minority government, which means that in order for them to pass in legislation, they need the willingness and consent of other members of other and different political parties to agree with them to get things done. So it's much easier to topple a government when it's a minority position, whereas it's relatively impossible to do that if they're in a majority position, all right? Cabinet, so our Constitution makes no mention whatsoever of the existence of the actual position of Prime Minister or that of the Cabinet. And the Prime Minister and the Cabinet, even though not mentioned in the Constitution, are in fact the bodies that run this country. Right, so the Cabinet is a group of, it's almost always members of Parliament. It doesn't have to be, but it almost always is. And so the Prime Minister chooses the member of his or her cabinet. We have usually between 20 and 30 MPs that are cabinet ministers, and each one of those cabinet ministers is in charge of a particular ministry or a department. The Department of Foreign Affairs, the Department of Finance, Department of Agriculture, they all have a minister that's in charge of them. And so they are the head of those ministries or the departments. And then they would have a deputy minister who is a civil servant who actually runs them. So they're the political head, but clearly the one that makes decisions relating to those ministries and departments, and who discuss their roles when you have cabinet meetings that the Prime Minister calls. So that is the executive branch of our government, which is elected and chosen by the Prime Minister as a function of being elected. In the United States, to contrast that, the cabinet that Donald Trump has are not politicians. They come from private industry, but when he makes a nomination for somebody to join a cabinet, it has to be affirmed by the Senate in the United States. So sometimes that's a difficult process, and one that is certainly different than ours. So in reality, in Canada again, Prime Minister chooses its cabinet members from his or her own party. They can bring cabinet ministers in from other parties if they so wish. In a minority government, sometimes that happens to keep these other parties on side. But again, that's totally a decision of the Prime Minister. Okay. Again, the House of Commons is made up of 338 MPs from across the country. Right, an election, and this is actually now according to the Charter of Rights and Freedoms, which is part of, it's a schedule to the Constitution Act of 1982. So the Charter says that an election federally must take place every 5 years. So no party can stay in power and form a government for longer than 5 years without calling an election to take place across the country. We do have a fixed election law in place that elections must take place every 4 years, but that's up to the Prime Minister's discretion. So while Justin Trudeau did follow that legislation the last time around, so he went from 2015 to 2019 with the next election, he can call an election tomorrow if he sees fit to do so. And there's a lot of speculation these days that he may well do that. His position in the polls is actually quite high. People tend to think that he's handled the COVID-19 crisis fairly well. He's certainly, been very transparent about what the government is doing. He's done daily, conferences and public announcements to the Canadian citizenry. And certainly he's dedicated a tremendous amount of resources to try to ensure that the country doesn't collapse at this time when we are all self-isolating, what have you. So if he decided to call an election for this fall, which would mean that his term of office would have only been 2 years, not 4 years, he has the authority to do that. And he might well do that when he is seen in a fairly favorable light at this time. But again, that's totally in his discretion. All right, we do have a Senate. So again, we have the House of Commons, which is those 338 members of Parliament, but we also have a Senate. So we have what's called a bicameral system of Parliament, where the Senate sits as part of our parliamentary system. The Senate are appointed by the federal government, again, by the Prime Minister. It's recognized in the Constitution as a parliamentary body, and therefore has authority has a lot of authority in the Constitution over a number of things to do. But having said that, it doesn't really do a lot other than oversee and do research to give support to the House of Commons. Again, because it's appointed, if it decided to try to change laws that the House of Commons put in place, it would be a problem, because you really don't want people who are appointed to be making decisions that change those of elected members of the parliamentary system. So while laws are passed by the House of Commons, they also have to be passed by the Senate before they go to the Governor General for signature. But again, when the Senate looks at these laws passed by the House of Commons, they can sometimes make suggestions as to how perhaps the law could be amended if they think that there's improvements that could be made. But the House of Commons does not have to accept any proposals for amendments made by the Senate. Okay, so let's talk about the legislative process and what that involves. Fundamental to the making of laws in Canada is a concept called the rule of law. It's a basic constitutional principle that basically sets out a number of policies and practices, but the primary policies are that although Parliament is supreme, those who make laws cannot act arbitrarily and in their own interests. So nobody is above the law to a great degree, right? And as another purpose of the rule of law, that the laws must be made known to the country so that everybody knows what laws are being put in place by those who are elected for that purpose. So that is the rule of law. The rule of law is again embedded into the charter, in the preamble of the charter. A very famous case dealing with the rule of law is Roncarelli and Duplessis. I know some of you are familiar with the case. I've called upon students in prior classes to discuss this. Obviously, I can't do this in a synchronous lecture, but I'll just tell you that this is a very famous case. It dealt with Duplessis, who was a premier of Quebec in the 30s and 40s, a very iron-fisted kind of guy who basically ran that province for decades. He took a personal disliking to Jehovah's Witnesses, which is a religious denomination. He's a Roman Catholic. Most of Quebec was, and to some degree still is, a Roman Catholic province. And what happened was that he basically, there was a lot of Jehovah's Witnesses being arrested for very spurious kind of reasons. And what Roncarelli, who was also a member of that particular denomination, what he did is he posted bail for all of those who were being arrested, and Duplessis took real offense to this. And what he did is he directed his Minister of Commerce to have those. Roncarelli ran a restaurant and had a liquor license, and what he did is he directed his Minister of Commerce, who had jurisdiction over liquor licenses, to revoke the liquor license of Roncarelli, which was intended to dry up his ability to have an income stream to post the bail for the Jehovah's Witnesses. And it, in fact, did do that. And so what happened is Roncarelli actually sued the Premier of Quebec, Duplessis, personally for violating the rule of law, in that Duplessis was putting himself above the law for his own personal purposes, his own animosity to Jehovah's Witnesses. And over the course of time, and it took 7 or 8 years for this to get to the Supreme Court of Canada. That's how long it usually takes a case to go from, a trial to that level of appeal. When it got there, the Supreme Court of Canada was incredibly angry with Duplessis, basically entered a judgment against him personally for what he had done. It was a Pyrrhic victory for Roncarelli for two reasons. A, he had died by the time it got to the Supreme Court of Canada, and B, because his business had been wiped out by his license being revoked, he in fact went bankrupt. So it really didn't do Roncarelli any good personally when it eventually got to the Supreme Court of Canada, but it did certainly make a point about no one, including somebody as powerful as the Premier of Quebec, is above the law. Okay, so let's turn again to the provisions of the Constitution Act of 1867, which is essentially just simply a renaming of the British North America Act of 1867. So Section 91 and Section 91 and 92 we're going to talk about in some detail. Section 91 of the Constitution Act basically sets out that the federal government has the power to make laws for what's called peace, order, and good government, which basically means that the federal government is paramount when it comes to making laws for the country as a whole, and it includes things like having the ability to make laws for emergency situations such as war or catastrophe. So for instance, as a function of this particular provision, it's now been renamed, but we had what was called the War Measures Act, which the country put in place during the First and Second World Wars. Put it in place during the FLQ crisis in 1970-72, all right, which basically gives the federal government a lot of power over everything that's going to happen that will basically bring law and order to the country, all right? It's an emergency power only during emergency situations. Otherwise, we have the other provisions of Section 91 and 92, which basically are there to delineate the powers between the federal government and the provincial governments. So Section 91 has a number of subsections that sets out, the authority that the federal government has over various things, and Section 92 sets out what the provinces have authority over. Remember, these two sections were determined by, again, Sir John A. Macdonald and what were then the colonial leaders in Nova Scotia, New Brunswick, Ontario, and Quebec, in 1864. So it was, so it's 156 years ago that these leaders got together and basically divvied up who would do what in this new country going forward. And they, with very little exception, these are exactly still the same powers that the federal government and the provinces have today. So, the way they divided up the powers back then is still the way the powers are divided between the provinces and the federal government now, all right? When it comes to the establishment of courts, the federal government has the authority to make appointments being appointing the judges to these courts, to the Federal Court of Canada. So that's the court that exists in Canada. If you are going to sue the federal government for any particular issue, and just the federal government, this is where you would bring your claim, right? And so you sue the federal government, and it's developed into quite a specialized court in that regard, particularly with respect to Indigenous issues, and I'll talk to you about that, why that's the case. But the matter of Indigenous law is a federal responsibility under Section 91, and so the federal court has developed a great expertise dealing with those kind of issues over the years. You also have the federal government who appoints members to the Supreme Court of Canada. So there are 9 members of the Supreme Court of Canada, and you get an appointment from the federal government. You actually get a phone call from the Prime Minister. So if you have been nominated by the federal cabinet, essentially, to sit in the Supreme Court of Canada, Justin will call you and ask if you would like to sit on the Supreme Court. And I'm sure he gives you some relative period of time to think it over. But if you want to be in the Supreme Court of Canada, you've made it known that you want to be there. So it would probably take about 3 seconds to respond and say, thank you, Prime Minister, I'd be honored to do so. Likewise, the federal government also makes appointments to all the superior courts of justice in all the provinces and territories across the country. So every province and territory has a superior court. So that's the highest trial division and appellate division within each province and territory. When they were originally created in 1867, again, remember the English law was imported into Canada then, they were called the Queen's Bench because in 1867, the monarch in Great Britain was Queen Victoria. So the 4 colonies that became 4 provinces had the Queen's Bench of Ontario, Quebec, New Brunswick, and Nova Scotia. And as provinces joined Confederation after 1867, they also created superior courts called the Queen's Bench of Manitoba, the Queen's Bench of Saskatchewan, and what have you, the Queen's Bench of Newfoundland, which wasn't until 1949. That's the latest province to join us. But you get the picture, right? Everybody established these courts. Over the course of the last 150 odd years, some jurisdictions have decided that that was a relatively anachronistic name to call their courts, their superior courts, so they've actually changed the names. So in Ontario, for instance, we actually no longer have a Queen's Bench of Ontario. We have what's called the Superior Court of Ontario, and that's just the name we use. So there's other provinces that have used that same name. In British Columbia, they call their Superior Court the Supreme Court of British Columbia, not to be confused, of course, with the Supreme Court of Canada. So that's a kind of a confusing name, but that's what they use it. Some provinces have still maintained the Queen's Bench. So for instance, Manitoba is still the Queen's Bench of Manitoba. Nova Scotia is still the Queen's Bench of Nova Scotia. You know, so we, across the 10 provinces and the territories, we have these different names, but they're all for exactly the same level of court. The original superior courts put in place as Queen's Benches in 1867. Provinces also have the authority, or have authority, to make appointments to provincial courts and to administrative tribunals. So again, the federal government makes appointments to the federal court, to the Supreme Court, and all the provincial superior courts. The provinces and territories have the authority to make appointments to what are considered to be provincial courts. We have 2 levels of provincial courts in Ontario. We have the Ontario Court of Justice, which is the provincial court for criminal law. So it is the lower court in Ontario dealing with criminal matters. So it deals with less serious criminal cases. It also deals with bail applications, no matter how serious the charge is. And it deals with preliminary inquiries, again, no matter how serious the charges. But you know, if the matter is, for instance, murder, you'll be in the provincial court up to the point of your preliminary inquiry. Then after that, you'll be going up to Superior Court of Ontario, the higher court. We also have a family court division for the provincial court. So again, the family court will deal with less serious matters in the family law. So it deals with custody and support. Not that they're less serious, they're very important issues in family law, but they have a provincial court jurisdiction for that. But you can also deal with custody and support in the Superior Court of Ontario, which also has the jurisdiction to deal with things like the division of property and divorce, which provincial courts can't deal with. Right, so it's the same across all the provinces, basically. Likewise, you know, provincially we appoint tribunals. So the Residential Tenancies Board, which is where you would go, or the Landlord and Tenant Board, which is where you would go if you had an issue with a landlord. And most of you, if you don't live with your parents, are renting accommodation. So if you have an issue with your landlord, you go to the Landlord and Tenant Board, which is appointed by the province of Ontario. Or if you have labor issues, you have the Ontario Labor Relations Board. So if you belong to a union, for instance, eventually you would go there if you have a matter that needs to be adjudicated beyond the normal processes of arbitration and what have you. Okay, provinces pursuant to Section 92 of the Constitution also have the authority to, or what's called the administration of justice. So all courthouses in Canada, with the exception of the federal court and Supreme Court, are built by and financed by the provinces. So the courthouse down at 426 Queen Street in Sault Ste. Marie, even though it has judges in there who are appointed by the federal government, it still is built by the provincial government. It's manned, as in its court staff are paid for by the provincial government. And for instance, the Crown Counsel, the prosecution in Canada, even though criminal law is a federal responsibility, prosecutors in 99% of the cases are provincial employees. They're appointed by the the Crown Law Office in Ontario, with the exception of federal crowns. I was a federal crown once upon a time. Federal crowns are appointed to do issues that are exclusively within federal jurisdiction, which for the most part, for the purposes of criminal law, is drugs and immigration, right? So it used to be a very, very big kind of, a big part of your job as a federal crown to prosecute drug possession, right? Which now is pretty much now been eliminated for the most part as a function of Trudeau, basically legitimizing and legalizing possession of marijuana in 2018. But there are still prosecutions for things like trafficking in narcotics and what have you. Provinces also have jurisdiction over legal aid. So that's something that, that provinces have to do, which provides funding for those who go through the system. So again, with respect to specific powers, federal government has authority over criminal law in Canada. So as I mentioned this earlier, criminal law is the same across the Canada. So the Criminal Code of Canada is a federal statute that applies equally no matter where you live in Canada. It's the converse of that is in the United States. Each state has its own criminal code. All right. So unlike Canada, which is a federal system for criminal law is fundamentally state controlled. Although the federal government does have some federal authority criminally in the United States, but it's much less prominent than the state's authority. Whereas in Canada, all criminal law is, with the exception of what are called quasi-criminal statutes, criminal law is federal. All right. Federal government also has jurisdiction over penitentiaries. So penitentiaries are where you're going to go if you've been convicted of a criminal offense and you've been sentenced to 2 years or more. So if whatever your sentence is, if it's just more than 2 years, then you're going to go to a federal penitentiary anywhere across the country. The provincial government has jurisdiction over what are called provincial offenses. So these are the quasi-criminal things like highway traffic and what have you. And the provincial government is responsible for provincial jails. So if you are sentenced to 2 years less a day, that's the terminology that is used, you will go to a provincial jail rather than a federal penitentiary. Likewise, if you are going to be in custody awaiting your trial or awaiting for bail, you're going to be in a provincial jail. Okay, so you never go to a penitentiary unless you've been sentenced. All right. Trade and commerce, again, think of these things in light of John A. Macdonald making his decisions, the decisions back in 1864. Trade and commerce is a significant role over the regulation, basically of trade across the country. So it's a federal authority. And this ties in very directly with what Macdonald basically said to the boys in 1864. So, let's all make money. And if we're going to make money, let's do it, as a combined federal government going across the entire country. And so what they all decided was that fundamentally trade and commerce would be a federal power. All right. So it relates to any trade and commerce between provinces or across provinces and dealing with other countries. So again, that's a federal jurisdiction. And if you think about it in today's term, and remember, this was put in place 153 years ago, 4 years ago. If you think about it even today, how many businesses don't do business that cross borders? Very, very few. The sale of grain, I should say oil, broadcast communications, things that didn't even exist in 1867 still fall within the trade and commerce provision of the Constitution Act, therefore being a federal authority, which includes radio, television, and the internet. So that's why the Canadian Radio and Television Commission has the authority to basically control the charges we pay to Bell and Fido and Rogers for our internet access. They have to approve those charges. And so when sometimes you hear that the CRTC is going to cap those charges, that's an exercise of the federal government's power over trade and commerce. However, provinces still have some trade and commerce power provincially with respect to things that take place within their own boundaries. And so historically, that's meant newspapers, the theater, and believe it or not, things like the film industry. They're considered to be provincial, not only because they're considered to be within a province, but they deal to a great degree with things like culture, which we talked about earlier. That's what the provinces basically kept to their own powers. All right, transportation as a power, Section 91 gives the federal government authority over shipping, railways, telegraphs, not that they exist anymore, all kinds of transportation, again, that connects provinces and goes beyond the country's borders. So that's a federal jurisdiction. And that includes things like trucking companies that cross borders. So again, that didn't exist in 1867, but it became part of the federal power over the evolution of time. Right? International treaties, the federal government, again, this is now a function of the Statute of Westminster in 1931. The federal government has exclusive authority for international treaties. So it is only the federal government that establishes embassies and consular offices around the world. So anybody who's outside of Canada deals with federal government employees in that regard. Note again that that particular authority wasn't contained in our Constitution itself. It only became a part of our division of powers after 1931. First Nations are a federal responsibility. So Section 9126 of the Constitution Act basically says that the federal government has authority over what's called, we still use the term, Indians and lands reserved for Indians. All right, so again, remember, this was put in place by Macdonald and the boys back in the day. When you look at all the papers that were prepared and the reports prepared at the time of Confederation as to who would have what authority, there is nothing in the records that show the assumption of authority of this particular matter by the federal government. And the reason is quite simply this. The discussion that would have taken place by Sir Johnny and the boys back at Charlottetown would have been, look, right, this is Sir John. We're going to go across the country, right? We're going to build this railway. We're going to make room for immigration to go into all this territory to create markets for our goods and services. To do that, of course, we have to go across lands that are occupied by these pesky Indigenous people who are already there and we know have been there for thousands of years. So, you know, the whole point of making this new country and expanding its trade and commerce, you know, to the ocean, the whole point of that being it's going to generate commerce. In order for that to work, boys, you know, as the person who will become the head of this new federal government, trust me, I'll take care of it. Right? So, you know, getting rid of the Indians and displacing them on their lands, whatever methods we put in place, which ended up being treaties, we ended up doing that, and discussion would have went like, you know, because it was never recorded, but, you know, it's impliedly what had to take place, because that's exactly what happened. All right? Having said that, while the Section 91 of the Constitution gives the exclusive authority over Indians and their lands to the federal government, there is some crossover with provincial jurisdiction because the lands, the ownership of lands themselves is Section 92 authority given to the provinces. So all the crown land that is in Canada is owned by the provinces. And what happened was, with the creation of the reservation system, reserves basically in Canada on these reserves, the lands would have originally been crown lands owned by the provinces, but when treaties were entered into and the reserves were created within that treaty land, those lands, in fact, would have been transferred over to the federal government because they had that jurisdiction to administer those reserves, and pursuant to mostly now the Indian Act of 1876, which is authority that is still exercised in that regard. So there is some crossover between federal and provincial jurisdiction when it deals with Indigenous peoples. Taxation is an incredibly important power in the Constitution because levels of government, all levels of government, including municipalities, need to impose taxes in order to raise income to exercise their authority. And so the taxation was divided between both levels of government at the time of Confederation, so they could do that. Natural resources, basically the same kind of rule for natural resources that applied to transportation and trade and commerce applies here, so that any natural resources that are basically national in basis that crosses boundaries minerals, oil, gas, wildlife, hydroelectric power. There seem to be federal kinds of resources within federal jurisdiction, but other kinds of resources like mining and forestry, I'm sorry, it's the other way around. Those things are provincial in that they're within boundaries, kind of thing, but things that are more broad like forestry and fishing and mining and things that are sold internationally and across provincial boundaries, they fall within federal jurisdiction. Okay. Provincial powers, again, most specifically are found in Section 92 of the Constitution Act of 1867. And the most important part of that authority is found in the provisions that say that matters that are of a property and civil rights nature within the province and all matters of a merely local or private nature, those are the kinds of things that the provinces retained authority over. All right, so that includes labor relations, business activities, local trade and commerce, regulations of how provinces are operating, the creation of municipalities and real estate. Those are all provincial jurisdictions. So for instance, municipalities are all creatures of provinces. So at some point in the past, there would have been put in place what's called the City of Sault Ste. Marie Act. That would have been a provincial statute that created Sault Ste. Marie. There likely would have been, prior to that, the Town of Sault Ste. Marie Act, when Sault Ste. Marie was a much smaller location. So those are creatures of provinces, and so the provincial government has total authority over whatever municipalities do. All right. Now, let's deal specifically now, the rest of this lecture deals with the constitutional division of powers and environmental issues, all right? So, environmental issues weren't something that the Fathers of Confederation dealt with. There's nothing in the papers or the reports generated at the time that said to anybody in that discussion that considerations dealing with the environment should be either allocated to Section 91 for the federal government or Section 92 for the provincial governments. That just didn't happen. So it's not a designated responsibility for either level of government, right? So, and therefore, in order to understand which level of government is dealing with the particular environmental issue that we're going to discuss in this semester, there has to be a bit of a constitutional analysis on the sources of the authority, federal and provincial, and that's why I'm giving you this lecture, because it has implications, obviously, for everything else we talk about, particularly dealing with environmental law, right? So there are specific heads of constitutional power that do provide, for instance, the federal government with legislative authority over the environment, and these things are just common sense to a great degree, but things that if you look at it, you can pay attention to it. Here's a YouTube. If you go to the PowerPoint that I put on Moodle and you go to this particular slide, you can click on this particular YouTube. It's only 4 minutes and 58 seconds that deals with the history of environmental policies in Canada, which will be part of the, to some degree, the lecture I give in class on June the 4th, dealing with basic concepts of environmental law. But go to this for interest's sake. All right. Now, these are the particular provisions of Section 91 that deal with things that are environment. So you have trade and commerce, 91 sub 2, navigation and shipping, 9110, fisheries, seacoast fisheries. These are obviously beyond the provincial boundaries, 9112, federal works, 9129. Indians and land reserved Indians, 9124. I think I might have said sub 26 before. That's criminal law. 9124 is Indians, so I apologize for that. So 9124. So these are the areas within the Constitution that can have an impact on issues of the environment, basically. And likewise, clearly you have again that provision in 91 that gives the federal government residual power over peace, order, and good government in emergency situations. And likewise, the criminal law gives you authority over, again, environmental matters that require prosecution. And we'll talk about that later in the semester. Right, so here's what the federal court has said with respect to environment. Again, remember, the federal court has jurisdiction over those who basically bring an action or sue the federal government for some purpose. So the federal government has said this, that all physical activities that have some environmental impact, positive legislative responses, such activities cover a large number of legislative powers, federal and provincial. Right? So that's the federal government basically acknowledging that both levels of government have jurisdiction dealing with environmental issues. And while criminal sanctions are designated to prohibit certain wrongful conduct, if the sanctions are for the purposes of regulation and not punishment, then they are not criminal. So they'll be dealt with provincially. So again, we'll deal with that in later classes, dealing with sanctions that are put in place by provincial authority, which likewise, again, comes from the Section 92 jurisdiction regarding property and civil rights and all matters of a private or local nature. All right. Other sources of provincial authority in 92 are basically include things dealing with the management and sale of public lands and timber, 92.5, municipalities, 92.8, licensing, raising revenue, 92.9, and local works and undertakings, 92.10. So as you can see, when we deal with all of these things we're going to talk about in this semester, dealing with laws that are put in place either by the federal government or the provincial government and municipalities, you'll see that they all flow from either sections 91 or 92 of the Constitution. Collectively, all those sources of provincial power do provide a strong constitutional basis for an extensive range of what are called regulatory initiatives. So we're going to have an entire class on regulations. So regulations are referred to as secondary legislation. So regulations are not statutes. They are laws that are put in place by the executive level of government. So both the federal and provincial cabinets, the individual ministries and departments, they pass regulations, which basically provides the nuts and bolts of how things operate. So for instance, just a very broad example, the Highway Traffic Act, which is a statute, says that laws can be passed to restrict the speed of vehicles on certain roads. And that's all the act will say. But regulations under the Highway Traffic Act will say things like, in a school district, you can only go 40 kilometers per hour, that kind of thing. Or on a highway, a 400 highway series highway, you can go 100 kilometers per hour. Those are the things that are going to regulations. So there's a lot of that in environmental law, dealing with very specific, usually scientific kind of issues. When we're dealing with the municipal government and the environment, obviously, and again, municipalities are creatures of the provinces and therefore do not have their own constitutional autonomy. It all flows from the provinces. But when the provinces do delegate powers to municipalities, they give municipalities the power to pass bylaws. So that's how laws are enacted by municipalities. So the city of Sault Ste. Marie, when it wants to pass a law, it passes what's called a bylaw. So it's not a statute or a regulation, it's a bylaw. Municipalities do have the authority, however, to regulate and manage environmental matters, which includes public health, planning and zoning, business licensing, dangerous substances, all those kind of things. They can be done by way of municipal bylaws and what actually are called municipal regulations, all right? With particular regard to Aboriginal rights in the environment, and we will have a good part of one class next week on this particular topic. Again, Aboriginal rights and the environment, within the constitutional framework relate to a number of things that go beyond simply the division of powers between the federal government, sections 91-24, Indians and lands reserved for Indians, and anything that the provinces may well think they have jurisdiction over. The most important constitutional consideration for Indigenous Canadians is found in section 35 of the Constitution Act of 1982. So it's not the Constitution Act of 1867, formerly the BNA Act, but this is the Constitution Act of 1982, which was obviously enacted by Pierre Trudeau's government. And what it basically says is that the existing Aboriginal treaty, this is entry, original treaty rights of Aboriginal Canadians are hereby recognized and affirmed, right? Which basically says that anything that is a treaty right, which now over the course of interpretation by the Supreme Court of Canada includes Indigenous rights that go beyond being in a treaty, that they're now constitutionalized, which obviously is a really, really important provision because as a function of that, they can't be interfered with, in a normal course of events because they are constitutional powers, right? The Supreme Court, in an early decision called Regina and Sparrow, established a strict test for any infringement of Aboriginal rights protected under Section 35. So in order for an Aboriginal right to be infringed, so here we're talking about a resource company, for instance, a company that hews timber or gathers water, anything dealing with resources, that, for instance, a provincial or a federal government may give a license to actually go on to Aboriginal territory to basically collect those resources. If they do that, and they do that without exercising what's called the duty to consult and accommodate, which is also a constitutional now doctrine applicable to Indigenous Canadians and their rights, in order for a level of government to actually infringe upon those rights, according to the Supreme Court of Canada, the Crown doing so has to, basically say very clearly and actually by way of statute that they intend to infringe upon those rights in a very clear and plain matter. So the legislation or regulation affecting those rights must be enacted, and there must be a valid objective in order to do so, which must be, most often must be related to the conservation or resource management. So if a level of government is going to infringe upon an Aboriginal treaty right or inherent right, and they're going to do so to perhaps much maybe contrary to those who are Indigenous on those lands, maybe contrary to what they think is appropriate, it will be justified, according to the Supreme Court of Canada's test, if the government can prove that the conservation or the resource management of the infringement is pervasive and for the betterment, for the most part, of the broader territory or the country, in order for it to be justified. Likewise, courts in this process have repeatedly underlined the significance of the honor of the Crown in dealing with Indigenous Canadians and the Crown's fiduciary duty in dealing with Indigenous rights, which simply means that when the Crown interacts with Indigenous Canadians pretty much in any matter, but most often matters dealing with their rights, which often deal with their territories, they must do so in a fiduciary matter, which means they must put the Indigenous rights ahead of their own rights. They must do it in a protective fashion. Treaty rights and land claim agreements, which are part of what are called modern treaties, also affect the nature and extent of Indigenous rights in resource and environmental management, and they have evolved quite appropriately over time to be very much directed toward protecting the Indigenous position on those lands. That's what the Supreme Court of Canada has enacted over the period of about 50 years of jurisprudence. Modern treaties, which are treaties entered into from 1975 forward, that was the first modern treaty was entered into between the province of Quebec and the Cree and Inuit in northern Quebec, which led to the development of the James Bay hydroelectric power plant. And modern treaties thereafter, this was the first time that treaties have done a number of things, but most specifically have incorporated environmental assessment and approvals into the process of making those treaties. So treaties before 1975 are considered historical treaties. Those are for instance, the treaty upon which this university sits is the Robinson-Huron Treaty put in place in 1850-51. It didn't have anything in it about the environment, really. It didn't have anything in it with respect to a lot of things that are now built into modern treaties. All right. Lastly, we'll deal with intergovernmental coordination, which again is something that's dealt with in more detail in Chapter 2. And basically, the theory is here, particularly when it comes to the environment, is that there needs to be, because of the overlap and ambiguity between federal and provincial authority, as we've just discussed in this lecture, the differences and overlap between sections 91 and 92, in order to minimize that ambiguity, we have to have essentially an intergovernmental coordination of activities. So that includes consultation between the levels of government and agreements reached between the various ministers. Again, these are members of the cabinet dealing with the environment for the most part. The Minister of the Environment for Ontario, for instance, dealing with the Minister of Environment for the federal government. You have those two positions. So hopefully they talk with each other, and they meet with each other, and they come to agreements each other for the mutual benefit of all parties concerned. So there can clearly be bilateral agreements between the federal government and very specific provinces, again, between the Ontario government and the federal government, or you can have multilateral agreements between the federal government and all the provinces. And most often that takes place when the federal government wants to adopt an international treaty, the Treaty of Paris, the Kyoto Accord, those kind of things, which we're going to talk about in more detail in this class. When the federal government enters into those treaties, they usually want to bring the provinces and territories in as partners in those treaties as well. All right. So anyway, guys, that is that's the lecture dealing with constitutional power and authority. Next week, we'll be dealing with environmental rights and more particularly what we're just talking about, the international context. All right. So thank you, and we'll discuss this and in the class on June the 4th, and a couple of questions in the breakout sessions will be relative to this particular lecture. Thank you.